The Supreme Court has adjourned to deliberate on the submissions made during the hearing of the BBI appeal. On its third and final day of the hearing, the court received submissions from several lawyers, with the petitioners, Attorney General, and IEBC lawyers asking the Supreme Court to throw away the Court of Appeal's decision on BBI. The 7 judges will now retreat to make a final decision on the BBI appeal on a date that will be announced later. Dickens Luvanda now reports.
All eyes will now be on the Supreme Court as Kenyans await the final verdict on the contentious proposed change of the constitution through the BBI bill, whose proponents are President Uhuru Kenyatta and the ODM party leader Raila Odinga.
To suggest that quorum ought to be read in to the constitution, whether or not there is legislation.
This is after the Supreme Court on Thursday concluded hearing the appeal by proponents and the IEBC, with the judges heading for a retreat to write their judgment.
We hope that the decision that finally comes out of your leaderships and your lordships' hands will be one that Kenyans will have respect for and that Kenyans will agree with, and that all of us will agree to be bound.
That brings us to the end of the hearing of this case.
According to the Chief Justice Martha Koome, the date for the final verdict will be issued at a later date.
The court will adjourn. The decision of the judges is that the judgment will be on notice. You'll be given a notice of when the judgment will be delivered.
Before the adjournment, the 7 Supreme Court judges had submissions from several lawyers representing different parties comprising both respondents and appellants, as lawyers challenging the decision by the lower courts, which declared the BBI null and void, insisting that the Court of Appeal and the High Court erred in terming the BBI null and void.
Parliament understands and knows the needs of its people, understands its history. When it did set the number of the IEBC commissioners as a minimum of 5 and a maximum of 7, it clearly took its mandate and understood what it was doing. So that registration that put the number as 5 has not been challenged in this court. It is not on appeal, and we urge the court to find.
So it is our very humble submission that we have demonstrated that there was quorum at all material times.
Just like the opposers of the bill, lawyer John Haminwa, who is opposed to the bill, asked the Supreme Court judges to dismiss the appeals in its entirety.
We have now current politicians, and there's very little really to admire them for. Recently I said in Court of Appeal that most of them, you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power. They don't seem to have really much that they can offer the country.
According to the BBI proponents, the bill sought to restructure the winner-takes-it-all electoral system by expanding the executive and parliament, but critics saw it as a way to enable President Kenyatta, who is barred from running for presidency again in the August 9th election, to remain in power by creating the position of the Prime Minister. Dickens Luvanda, Hope TV News Watch.